Hear ye, hear ye, hear ye. Colorado Court of Appeals is now in session. Please be seated.
Hi, good afternoon. This is Division 7 of the Court of Appeals. I'm Judge Karen Ashby. I'll be presiding today. To my right is Judge Jerry Jones, and to my left, Judge Elizabeth Harris. We have two matters on the docket this afternoon. The first being People v. Curry. It looks like counsel are at counsel table and ready to proceed. And I assume each of you has received a copy of the policies and procedures for oral argument. Any questions? Okay, and we are live streaming, so if there's any sensitive information you don't want out there, be mindful of that. And I'd ask everybody in the courtroom to turn off your phones, please. They apparently actually interfere with some of the technology, so if you could turn them off rather than just silence them, that would be great. All right, so let's proceed then with People v. Curry.
Good afternoon. Malika Magner, attorney registration number 27149 for defendant appellant Leantoine Curry. I'd like to reserve 5 minutes for rebuttal. May it please the court. A horrific murder. An old woman killed for her bingo trip money. Mr. Curry, fingered by his girlfriend, Lakia Hughes, makes a detailed confession. The girlfriend testifies at trial that he also confessed to her. The troubling inconsistencies and unanswered questions in the confession and physical evidence are swept aside. Hughes receives a deal prior to the return of the DNA results. The defense argues at trial reasonable doubt, urges the jury to consider those anomalies and inconsistencies, but there's the confession of Mr. Curry and Lakia Hughes' testimony that he confessed to her. Of course the jury convicts. But now we have another confession. A confession which, if believed, raises reasonable doubt as to Mr. Curry's guilt. The hearing court abused its discretion in finding that the evidence of this new confession would not result in an acquittal. The evidence and justice demand that Mr. Curry receive a new trial. Instead of looking at whether the evidence as a whole would result in an acquittal, the hearing court looked at whether or not Morton's testimony, the cellmate to whom Lakia Hughes made her unsolicited confession, the court looked at whether that testimony would provide a new and more credible account of events than that already presented at trial. The hearing court and the experienced homicide prosecutor both found that Ms. Morton was credible. The evidence was clearly established at the hearing that Ms. Morton and Ms. Hughes had shared the same cell together. Ms. Morton had had the opportunity to use this evidence to gain benefit in her own case. She was so frightened of Ms. Hughes. She was so frightened by the hours-long account that Ms. Hughes had given to her, acting out the murder, giving details, swinging her arm up and down to show how she had committed the murder.
Could I jump in here just for a second? Could you be a little more specific about what you think in terms of the standard that the district court applied, what you think in very particular terms the district court did wrong? I mean, give me an example of what you think the exercise should have been, and then what you think the district court did do, and why Mr. Curry would win under one and not under the other.
Well, the court applied a standard that resulted in the denial of his obtaining a new trial. what the court should have done was the court should have looked at the evidence that was adduced at the original trial as a whole. And then, having reviewed the demeanor of Ms. Morton, of having heard her testimony, of having seen her, taken that evidence, which is what would be presented at a new trial, and made the determination as a whole, would this new evidence as a whole resulted in reasonable doubt for Mr. Curry and thus an acquittal. But what the hearing court did instead was the hearing court required that in order to make a finding that Mr. Curry would be entitled to a new hearing, he looked at each one of the inconsistencies that as a whole together established the reasonable doubt. So for example, Mr. Curry said that the disabled person whom the victim was the full-time caretaker wasn't in the apartment. She was in the apartment. The evidence also at trial was that even if she had been under the cover, she was in the same bed with Ms. McCauley, the victim. The evidence was that she was kind of fat, and that for certain, anyone who was in the room would have seen the little Nita, as she was known as. Mr. Curry, in his confession, said, no, there was nobody else in the apartment. The testimony, his evidence was that he had sat and watched TV on the bed with the victim. So we have testimony and evidence that little Nita was in fact there. That's not disputed. But what the trial court said when faced with this particular inconsistency, the trial court said, well, the testimony of Morton, the cellmate, when she recounted the confession, Hughes didn't say anything about little Nita being there. So the fact that the confession, which was given by Ms. Hughes, didn't specifically address this inconsistency, the court said, well, then the confession doesn't help.
But isn't the exercise that the court is doing, doesn't the court have to determine whether or not a jury's already convicted Curry, right?
Yes.
Okay, so they heard all the evidence and they convicted him. Now the judge has to determine whether throwing Ms. Morton's testimony about what Ms. Hughes told her into the mix is going to change the jury's mind.
Yes.
Right?
Absolutely.
Okay, so the judge has to look at how persuasive, like what kind of value Ms. Hughes's statements have when you put those statements up against all the rest of the evidence.
Absolutely.
Okay, and that's just what the district court said it was doing, isn't it?
Except the court went through example after example after example. And when a jury hears this new confession that was obviously very powerful, the hearing court found that nearly 11 years later, Ms. Morton was still frightened. Ms. Morton's testimony at the hearing was so powerful and so persuasive that the judge and the prosecutor believed her. Yet, the court, in its analysis, instead of making the analysis, okay, here's this powerful testimony. We've got dueling confessions. And as the hearing court found, the physical evidence was equally damning to both of them. The DNA pointed equally to both the defendant and to Ms. Hughes. So it all came down to reasonable doubt. Would they have found Mr. Curry innocent? That's not the requirement. It's would this powerful, persuasive testimony, in light of all these other strange things that didn't make sense, that where there was one confession was certainly easy to convict Mr. Curry. It was easy to sweep those things under the rug. He confessed. Why would somebody confess? And what the prosecutor on summation said, yeah, the defense wants you to believe that maybe Ms. Hughes did it, but they didn't present any evidence. this is the evidence that would persuade the jury. This powerful, persuasive, detailed testimony that persuaded both the prosecution and the judge.
Well, but,
Counsel- I'm sorry.
go ahead.
The court didn't say that the testimony persuaded the court. It's one thing that it's credible. In other words, the cellmate testified credibly, okay? But the trial court made a point of noting that doesn't mean the defendant, not the defendant, Ms. Hughes was telling the truth, okay? And so to examine whether it was powerful or not, the court had to go through all of the evidence and stack it up against the alleged confession, which is exactly what the court did. And so, I mean, you're criticizing the court, it seems to me, for doing exactly what the court was required to do. When Hughes gives detail X, the court is to look at the evidence to see whether that comports with the rest of the evidence. And that's what the court was doing.
I would argue that what the court was doing was not that. What the court did was comparing the two confessions and saying essentially that the new confession had to refute all of the inconsistencies in its full content. And that's not what needed to happen. To persuade a jury doesn't need to hear that actually the confession said where the victim was found, whether she was found on the bed or whether she wasn't. In order to be persuaded, a jury has to find that there was reasonable doubt. There are now two people who confess.
Well, okay, but so that seems to be really sort of like the nub of the argument here. So what you're saying, it sounded to me, was, well, the mere fact that we've now thrown another confession in, obviously that changes the entire dynamic of the trial. Is that your argument?
Not the fact that it's just any confession. The confession gave enough details that made it clear, and the judge made the finding that Ms. Morton had in fact spoken, Ms. Hughes had in fact spoken to Ms. Morton. So the judge finding her credible is a huge burden, because she stands up there and she says, she told me she did it.
But Ms. Magner, it seems to me as though you're arguing along the lines of the dissent in Farrar, where the dissent was saying if you end up with this, in that case, recantation, which in essence is what we have here. We have Ms. Hughes through Ms. Morton changing her testimony and saying that rather than Curry doing it, it was her who did it. And in fact, the majority in Farrar, though, said that there's more analysis that needs to happen than just the fact that we now have another version, and that in and of itself is impeaching enough of the witness credibility in the version she gave at the first trial that that should result in a new trial. So it seems to me as though you're arguing what the dissent in Farrar says should be the analysis that the court goes through,
Well,
rather than what the majority said the analysis should be.
I do cite the Farrar dissent in my brief, and I do think that in this case, the Farrar dissent is applicable, because I don't see this as a true recanting witness case. The recanting witness case, as I see it, as the other cases that are cited in the briefs, it's a witness who gives a testimony at trial and then later changes her mind.
But didn't the majority say we're not really setting up a different standard for recanting witnesses or other newly discovered evidence? And so we're kind of left with the Farrar majority, which is the analysis that the trial court did here.
Your Honor,
It sounds like you're arguing you'd prefer that it be the analysis that the dissent was arguing for, but we're obligated to follow what the majority tells us to do.
Your Honor, I argue that regardless, that in this particular case, under these particular circumstances, the introduction of this evidence the details in the confession, the corroboration of the confession, the fact that the cellmate could not have known these details, the fact that the court did find that she had spoken to the cellmate, that this particular confession under this particular circumstances, if a jury heard it, given the other troubling inconsistencies in the trial evidence and in the confession, would result in an acquittal. And I'm going to reserve the rest of my time unless you have further questions. Thank you.
May it please the court. Grant Feverly, registration number 42318, on behalf of the people. The trial court properly determined in this case that the newly discovered evidence would not have probably resulted in an acquittal of the defendant. In doing so, in a detailed written order, it correctly determined and applied the Farrar and Gutierrez standards in determining the weight that a jury would give this evidence and the lack of materiality that would justify an acquittal in this case. I want to start with talking about some of what defense counsel was talking about in terms of the fact of conflict between the purported confession of Ms. Hughes as told to Ms. Morton and her testimony at trial, as well as all of the statements she made to the police throughout the course of the investigation. The test is very clear that the mere fact of impeachment is not enough to justify the granting of a new trial. That's prong 3. What is required is that the evidence is material, that it be consequential enough in its own right to produce an acquittal. Not a different result, not the probability of a hung jury, but the probability of an acquittal. And in this case, the evidence simply doesn't do that. The evidence, as testified to by Ms. Morton, is inconsistent in a number of important areas. It's questionable as to the circumstances surrounding its disclosure that draw into question its accuracy. And even if believed by the jury, it would not necessarily preclude the defendant from being found guilty of first-degree murder, because the evidence does not affirmatively remove him from the scene or affirmatively remove him from participating in or planning the commission of the crime so that he could be found guilty under a different legal theory such as complicity. Starting first with the inconsistencies in the statement itself, Ms. Morton, relaying Ms. Hughes' statements, gets wrong the fact that Ms. Hughes was not a certified nurse assistant, gets wrong the fact that the victim was not going to take a cruise, gets wrong the fact that Ms. Hughes could not have seen the victim in the afternoon of one of these days, given the other evidence in the case, the timing that the victim was seen at 6:30 p.m. on the evening of February 12th, 2004, and that her phone was busy throughout the day of February 13th, 2004, which is consistent with the coroner's time of death, which is consistent with the defendant's explanation of how he arrived at the house at the apartment at approximately 11:30 p.m. It's consistent with his description of how the death occurred, that she may have lived for a short time thereafter, but died probably in the early morning hours of February 13th, 2004. Ms. Morton gets wrong the fact that the weapon at issue was not a claw hammer. It was a ball-peen hammer. She gets wrong the fact that the commission of the crime did not pull out the victim's brain matter as the hammer was going in and out of her skull. That was very clear from the testimony. I would also note that the inconsistencies the defense counsel points to are not any further resolved by the admission of this purported confession of Ms. Hughes. She points to all of these, all the forensic evidence that point to both of the individuals as potentially being involved. Well, the new statements of Ms. Hughes don't explain those in any way. She doesn't talk about the fact that little Nita was in the apartment. She doesn't talk about the fact that she had any injuries or had any blood on her clothing as a result of committing this attack. It doesn't move the needle in any appreciable way in that regard. The evidence also doesn't explain why the defendant confessed repeatedly and in material detail on 3 different occasions to officers. It doesn't explain that, according to the defendant, he was fed these details by Ms. Hughes. That's completely absent from Ms. Morton's testimony. It doesn't explain that the defendant falsely confessed to committing this crime. There's no evidence in the post-conviction hearing from the defendant that he did in fact falsely confess. Frankly, it just doesn't rise to the level of the materiality required that would produce an acquittal in this case. The circumstances of the confession also raise significant questions about its accuracy, as the trial court found. He talked about the discrepancy in the jail records. Ms. Morton was adamant that she only spent 1 day in the jail cell with Ms. Hughes, and she was so scared as a result of the statements that were being made to her that she immediately demanded her removal. The records show that she was in a cell with Ms. Hughes for at least 4 to 5 days. The testimony at the post-conviction hearing revealed that the verbatim notes that Ms. Morton testified that she took immediately upon the conclusion of this heart-to-heart with Ms. Hughes were sent right away to her attorney or within a few days thereafter, because she was scared of reprisal from Ms. Hughes if they were found in her confession. But Ms. Morton's defense counsel testified below that she didn't receive those notes for approximately 4 months. There are also issues within the notes themselves. It includes the misspelled name of the defendant as being mentioned within those notes, but she testified at the hearing that the defendant's name wasn't mentioned one way or the other during that initial testimony, and that she had to do additional research or look into the matter on her own in order to discover that name. That again calls into question the accuracy of those notes. And finally, turning to the fact that even if a jury were to not only believe the statements of Ms. Hughes as relayed by Ms. Morton, that doesn't necessarily preclude the defendant from being found guilty in this case. I would point the court to the Mason case, which arose in the withdrawal of a guilty plea. However, the analysis on the prejudice prong is the same as that of Gutierrez. It's the 4th prong in Gutierrez. It's also part of the test for withdrawal of a guilty plea. In that case, the newly discovered evidence was the letter from a witness who had testified at trial, admitting that he was the one that actually committed the stabbing at issue in that case. That court denied the motion for post-conviction relief because it found that that letter didn't actually remove the defendant from the scene of the crime, and the defendant could still be found guilty under a number of theories that wouldn't result in an acquittal. The same thing here. The defendant obviously knew a lot of detail about the interior of the apartment. The murder weapon was found in his possession, and he directed the officers to that location. A jury could clearly infer that even if Ms. Hughes was the one that swung the hammer, that he was still guilty of first-degree murder under a complicity theory because he intended that crime to be committed and aided, abetted, planned, or participated in its planning or commission.
Counsel, would you agree that the court could have gone the other direction in finding that the confession that Ms. Morton testifies Ms. Hughes gave her could have impacted the outcome of the trial? It seems as though we're talking about this as though it's a science as opposed to it really is a matter of the court exercising its discretion and making a judgment call based on the evidence that it made. And another judge may have gone a different direction, but our purpose here is really to decide whether this particular judge abused his discretion in going the direction he did.
As a general matter, certainly a different court could reach a different conclusion based on its weighing of the evidence. In this particular case, I believe the trial court reached the correct decision in the manner that it went about analyzing this evidence and in applying the standard of Farrar. Taking the evidence as a whole, which is what the court did, it evaluated not only the importance of this confession on its own, but also in the context of the evidence that was adduced at trial as a whole. These motions are viewed with great disfavor, and recantation evidence, which is essentially what this is, the statements of Ms. Morton on their own aren't necessarily at issue here in terms of her personal credibility. It's the statements of Ms. Hughes and the importance of her, quote unquote, recanting her prior testimony that's the heart of the issue here. Recantation testimony is viewed with great skepticism by appellate courts, and for good reason. In this case, the circumstances lead to those questions about the accuracy of the statements, the truthfulness of those statements. And you have to look at the evidence as a whole, the evidence that was actually produced at trial, which in this case points very strongly and overwhelmingly towards the defendant and his commission of this crime. So in this case, the court thoroughly explained its reasonings and is justified by the record in reaching the conclusions that it did. It did not abuse its discretion in denying the request for relief.
Can I ask you a question about that? How is this recantation testimony? Recantation is when a witness who testifies one way at trial then says, never mind about all that, I'd like to now testify a different way. That's not what happened here.
Correct. It's not a traditional recantation in the sense that Ms. Hughes got on the stand and testified, all of that stuff I said previously, this is what actually happened. What it is, though, is testimony of Ms. Hughes as relayed by another witness that directly contradicts her prior testimony.
Right, but contradictory testimony is not necessarily recantation testimony. One, we would view with much skepticism, I agree, just like they said in Farrar. But the other, let's say she was caught on a recorded line confessing to her mother. We wouldn't say like, I can't, you recanted, we should view that with so much skepticism. So those two things seem different to me, which is going to lead to my next question. So Ms. Magner says Farrar doesn't apply because that applies specifically to a recanting witness, I would say really specifically to a recanting victim witness. Do you think that the district court's analysis is dependent on Farrar applying to this case?
No, I don't. If you reach the trial court's conclusions, it finds that the evidence would not have probably resulted in an acquittal, which is directly the fourth prong of Gutierrez. That's restated in Farrar as well. But I should point out that the Farrar reasoning specifically talks about the fact that the appellate courts in Colorado have not classified types or categories of evidence and changed the analysis based on whatever type of evidence is at issue, whether it be a new confession, whether it be recantation evidence, whether it be newly discovered video footage that wasn't previously known. That analysis is subsumed and already incorporated into the Gutierrez and Farrar standard. And explicitly distinguishing the fact that it does not apply specifically to just recantation cases. It applies broadly to all newly discovered evidence cases, and Farrar is an illustration of how a court should go about determining the impact of that evidence on the case as a whole. If there are no further questions, I would simply ask the court to affirm the trial court's order.
The district court, in its written order, specifically cited Farrar under its standard of review section. So the district court was absolutely utilizing the standard of review set forth in Farrar, and this is not a recanting witness case. The other thing is that I would ask you all to, the people talked all about the testimony of Ms. Morton at the hearing, but what is more germane, as the district court found, was not her testimony, but her written notes. The district court specifically found, with the passage of almost 11 years, yes, there were some discrepancies in her hearing testimony, but that her written notes were far more in congruence with the trial testimony. I think that's it.
Before you sit down,
yes,
can I
sir.
just ask you
Ma'am.
a quick question? Can you address this concept that maybe the confession, Hughes's confession, is not really sufficient because it could nonetheless implicate Curry in the crime, or it wouldn't exclude him?
There was never a question of complicity, that there were two people. There was no evidence that there were two people. This is the first that I've ever heard that he would be charged under complicity theory or that he could otherwise be convicted. Also, Ms. Morton did testify that it was her understanding from Ms. Hughes that Ms. Hughes had done it alone. And Ms. Morton testified at the hearing, as did Ms. Hughes at the trial, that Mr. Curry would do anything she said. Thank you.
All right, thank you, counsel, for your arguments, and an opinion will issue in due course. Looks like people are ready on people in the interest of GSS. So we have a number of people. Are you going to be making the entire argument today?
No, Your Honor, and I was going to do the introduction when I got up here, but I'm happy to do it now. I will be making the argument on the first section, and with me at co-counsel table are Sean Murray and Robert Barlow from the Durango.
Okay, and no questions about policies or procedures, and again, understanding that we are live streaming any sensitive information you may not want to be out for everyone to hear, then just be mindful of that. Okay?
Yes,
We're
ma'am.
ready? Okay.
Good afternoon, Your Honor. My name is Joseph Michaels, attorney registration number 40403. With me today at counsel's table are Sean Murray and Robert Barlow. We will be addressing two separate issues today. The first of which is that if this is indeed a speedy trial issue, then the tolling provisions of 18-1-405 sub 6 sub F must apply. And if it is a no bond holding issue, specifically under 19-2-509-4B, then that subsection does not demand dismissal of the charges. In fact, that subsection suggests that the better option is either to have a bail hearing or immediate release, or to put the juvenile into a pretrial diversion type of program. Mr. Murray and Mr. Barlow will address that second point, and I will address the first point, the continuance question. Now, I said that if it is a speedy trial issue solely, it would be under 18-1-405 sub 6 sub F. But that's also true, quite frankly, if it is a no bond issue, because this court and our Supreme Court have routinely held that the continuance requests by defense counsel for the purposes of extending a trial, extending a proceeding, are chargeable to that defendant.
Counsel, I want to ask you about that because I'm not sure I understand the process here in the juvenile context.
Certainly.
We have several hearings that are detention hearings. I think at least one dispositional hearing in the mix. And there's an argument in the brief that by continuing these types of hearings, the trial court could not set a trial date. And I'm wondering why that is so.
In this case, and under the facts of this case, how it was set up was the parties were trying to plead in order first to get a more favorable detention hearing, and that was something that the defense counsel in this case made explicit routinely throughout these continuance hearings. And they were trying to do it in order to effect a plea disposition. And as the Supreme Court has held in Maines, and I'm going to butcher this name, I'm sure, but Luveno, which is cited in the brief, continuances that are made in furtherance of a plea disposition are chargeable to the defendant and effectively toll that speedy trial requirement.
I understand that piece. I'm trying to understand, there is an actual argument in your brief that the court couldn't set a trial date. Okay. I assume that means there was some law that prevented it from setting a trial date. But what was that?
There was the defense counsel's argument that was saying we don't want to enter a plea yet. We're not proceeding to trial. We're trying to secure a detention hearing.
But
So
what, okay, I understand that, but what precluded the trial court from saying, okay, but I'm going to set a trial date, here it is?
I'm not sure anything did, except for the fact that the parties were making these good faith representations of progress to the court, and that the court understood that the parties were trying to facilitate a favorable outcome and a favorable disposition for this particular juvenile, both in terms of achieving a favorable plea, but also in terms of achieving a favorable detention release program. The trial defense counsel in this case explicitly said, we want to get this juvenile evaluated. We want to assess him for a proper release program. We want to assess his mental condition. We want to make sure that we can find proper evidence of mitigation to pursue that plea.
So can I interrupt you then? In terms of the continuances, at least up until June 27th, it seemed as though everybody was saying, we can't talk about releasing this young man from detention until we have some assessment done. The DA was objecting, the court was saying that it couldn't decide on release until there was such an evaluation. So how can we attribute that delay in getting information pertinent to the detention as a basis to extend what was a speedy trial right?
Because that was explicitly what the defense counsel was requesting of the court.
Actually, I don't see anything prior to June 27th where defense counsel says anything about disposition.
The defense counsel, from May 2nd on, from the initial detention hearing onward, is representing to the court that I don't want to proceed to a detention hearing. I don't want to proceed
To detention hearing.
to a detention hearing, to a dispositional hearing, to anything without getting this particular juvenile assessed.
Okay, I think there are two different issues and two different hearings, though. There's detention hearing, and then there's dispositional hearing, and it was the court who ultimately set a dispositional hearing for that June 27th date because there hadn't been an offer even made. And the defense counsel on June 27th says, in fact, they had been advised by the district attorney if they entered a not guilty plea, they were going to stop any possibility of negotiating.
But there had been a plea extended to that juvenile who had then rejected it at that time in order to get further mitigation.
So are you saying that the court and the prosecution had no obligation to set a trial date in order, because of a specific statement made by defense counsel? And if so, can you point me to the specific statement in the record that you're referring to?
The specific statements occur, and I emphasize them in both the reply brief and the opening brief. They talk about the defense counsel's request that we don't want to go forward with this. We want to pursue this evaluation. We are not ready to go to a dispositional hearing. We're not ready to go to a detention hearing because we're trying to get to the defendant's, to the best possible position, negotiating position before we go on.
Are you referring to June 27th? I'm just asking you to point me to the specific date and statement that you're referring to.
On the June 13th, it looks like defense counsel, the prosecution extended a plea offer on June 13th, which the defendant rejected. That's in the supplemental or suppressed file at 43 to 45. And defense counsel explicitly pursued continuances starting as of May 2nd, again on May 5th, and again, May 2nd and May 5th. May 2nd is page 6. May 5th is page 3.
Continuance of the dispositional hearing or the detention hearing?
That was at the time of the detention hearing. And then on the suppressed court file on page 43, the defense counsel specifically said they were awaiting the evaluation to negotiate more effectively. So they're pushing this evaluation, they're pushing this dispositional hearing out in order to get more facts and a better plea situation for them.
And wasn't it correct that at each of those hearings, though, they also asked the court to release the defendant based on the release plan they had submitted earlier?
That I don't think is so. I think they were waiting to make sure that the release plan was effective, would have been approved by all the parties. And I don't think that they had that. They were still waiting to get the release information.
Well, can I ask a follow-up about that?
Sure.
At the May 16th hearing, I think that the kid's lawyer says, look, I don't think you even need an evaluation. I think you should just release him on the release plan we have, and the prosecutor says, no, I'm not agreeing to that, and the judge says, I want to see something. It doesn't have to be a full-blown evaluation, I want to see something.
The problem with that, Your Honor, is that under 19.2508 sub 3A 4D, it explicitly says that at that initial detention hearing, it subjects it to the juvenile speedy trial statute, 19.2108. 19.2108 says that when a defense counsel asks for continuances under 18.1405, 6F, then that is still attributed to the juvenile in this case.
Okay, but I just want to clarify. So it sounded to me like what the lawyer was saying is, I'd like you to release the kid. And the judge says, I don't want to do that until I see an assessment. Then there's all these problems trying to get the assessment. But does that count as I don't understand what you think the lawyer should have done.
That still does count as a continuance, because at that point, we have an initial detention hearing under 508, 19.2508, which then triggers that 60-day limitation, at which point the further continuances that go on and on and on and on are attributable to defense counsel. In terms of the remedy, I want to turn it over to my co-counsel to address that, which hopefully will clear up any more questions, unless you have any further questions that I can answer. Thank you.
My name is Sean Patrick Murray, attorney registration number 44009. So, as Mr. Michaels indicated, I'm solely going to be addressing the issue of the appropriate remedy if there was a breach of 19.2509, subsection 4B. So I'll start with what I would call the weakest aspect of my case, and then I'll finish with what I think is the strongest part of our argument regarding remedy. The weakest part, as was explained in the answer brief, is the issue of settled construction, and that two divisions in the TA case and the GWR case both looked at this issue in kind of a different way and assumed that dismissal was the appropriate remedy, assumed that this statute codified a speedy trial right. I think it's important to look at the specifics of those cases, and I don't believe that assumption that they had is an accurate reflection of how to remedy a purported breach of this bail statute. So in GWR, the juvenile argued that he needed to be tried or released within 60 days, and we would agree with that interpretation, that if from the issuance of the no bond hold or a bond that a juvenile can't post, if 60 days goes by and the juvenile is still in detention, they should be released at that time. In GWR, they found that there was a waiver under subsection 5.1 of 18.1405, which is in essence, if defense counsel is present with the juvenile and the trial court says, I'd like to set this date, and that date is outside of the 60 days, that operates as a waiver of speedy trial when they accept that date, when they don't object to that date. While it isn't explicit in GWR, you can infer from the language of that case that a not guilty plea was entered. In TA, the other case regarding settled construction, there was an explicit reference to a not guilty plea. In that case, what happened was the juvenile had been committed to youth corrections in a separate case, and then the trial court was concerned that that juvenile wouldn't get treatment services, wouldn't be able to do that if the no bond hold remained in place in that instant case. And so the trial court converted it to release the juvenile.
Counsel, can I interrupt you just because I don't want you to run out of time before I have a chance
Sure.
to ask you my question? So in 19.2509, 4B, when it talks about the 60-day period, it doesn't limit it to considerations of bail. It says must be tried on the charges on which the bail is denied or bail is revoked within 60 days after the entry of such order, the no bond, or within 60 days after the juvenile's entry of a plea, whichever date is earlier. What's the point of pulling in the not guilty plea and saying whichever is earlier if you're not intending to affect the time within which the trial needs to be held, and the trial being the operative concern here as opposed to release from detention?
Yeah, I think that's a really good point. And
Thank you.
One of the things that we argued in the reply brief was that specific language
Because
connotes...
that's not in the adult statute.
Correct. In the adult statute, we're talking about the bail statute. Okay, yes, that's correct. And one of the distinctions with the adult statute too is it does have that explicit remedy that you shall set the bail hearing and shall set an amount of bail. But I think that's an important statement regarding the fact that there are two operative dates. And so this is what I would call the stronger argument. And so what 19.2509 describes is not only a date regarding when the no bond hold issued or when the bond was raised and the juvenile couldn't post it, it also designates and assumes, based on that language, that there was also a not guilty plea. And so if we interpret 19.2509 4B as a speedy trial provision, we are effectively nullifying 19.2708. We're nullifying the entire system of pleas, where a juvenile such as this juvenile could be forced to trial, even though he's saying to the trial court, we don't want to litigate this case. We
Well,
want,
the remedy to that is just ask for continuance.
sure.
So I don't understand the forced part.
In the sense that, well, and I think this kind of comes full circle with how 19.2708 says that the court shall set an adjudicatory trial at the time of the not guilty plea, which is language that is not found either in 19.2508 or 19.2509. That there's nothing that prohibits the trial court from setting a trial upon issuance of the no bond hold, but it's not mandatory in the way that it is with regards to a not guilty plea. And so if this were to be interpreted and constructed in this way, that statute, 19.2509, would render the entire plea system irrelevant. A juvenile, and if they didn't want to go to trial and the court said, well, we don't have a plea disposition at this time and I have to try you within 60 days, then you have to move to continue. If a juvenile didn't want to move to continue, if a juvenile wanted to enter into a plea disposition but they hadn't gotten that done yet because they didn't have an evaluation, then a juvenile could be forced to go to trial, even though they wanted to enter into a plea.
Counsel, let me ask you about about 18.1405. Now, my understanding is that the only reference to that in the juvenile statutes is in 18.108, 208, 18.1208, I forget.
19.2108,
19.2.108, okay.
sure,
But it's not in 509.
correct.
Okay, but even 18.14051, which is the only provision I'm aware of that talks about dismissal of charges, ties that to an entry of a not guilty plea. So even if 405 applies, how could it possibly apply in this case?
I
You
think
don't have a
that's,
not guilty plea.
I think that's right. Absent a not guilty plea, 48, rule of procedure 48B and 18.1405 don't apply. To the extent that the court disagrees with me, if it's going to incorporate or import that language from the adult statutes into 19.2509, it also has to incorporate subsection 6 of 18.1405, which is the tolling provision. So if I'm wrong, and if this is a speedy trial statute, and the only cognizable remedy is dismissal, then that shouldn't have happened, because the juvenile was the reason that the tolling occurred.
Counsel, I think you're out of time.
Oh, can I just ask a question?
Yes.
Thank you. Okay, but just to finish where it sounded like you were going, but if it's not a speedy trial provision, and it's just a bail provision, then you say, well, then the remedy would be that you have to let him out. This says no keeping the kid in jail for more than 60 days. Okay, so that all sounds fine, except that when you point to the adult bail statute, it has it right in there. It says, or you have to let him out. Why doesn't it say it in here?
And so that's why I refer to it as an implicit remedy, because it says, and who remains in custody or detention. And so while there is an explicit remedy in subsection 2 of 19.2509, the pre-adjudication service program, which is about reducing pre-adjudication detention without sacrificing community safety, this is more of an implicit indication based on the plain language of what can be done, and who remains in custody or detention. And the division in TA said the exact same thing. Had the juvenile been released home rather than remaining in custody on his adjudication in the other case, the purpose behind the expedited speedy trial statute would have been satisfied. So they're agreeing that if he had been released, the purpose behind that statute would have been satisfied.
Thank you. And we should allow or add a minute 55 to appellee's time.
Good afternoon. Ryan Hardman, registration number 37922 on behalf of GSS, the juvenile in this matter. May it please the court and counsel. This case is simple. 19-2509 requires that when a juvenile is held without bond and the juvenile remains in custody, the court must hold trial within 60 days of the no bond order. Here, the court ordered that GSS would be held without bond, and GSS remained in custody. It was the prosecution's and court's duty, not defense counsel's duty, to bring GSS to trial within 60 days.
Even if he didn't want it? Well, his lawyer said he didn't want to do that on more than one occasion.
On
More than one occasion, his lawyer said, we need to put this off. We want to negotiate. I need the evaluation first.
So there were two things going on in this case. I completely disagree with the state's characterization of the facts. Defense counsel wanted release of GSS, and that's what she was advocating for. She was also trying to get an evaluation to comply with the prosecutor's and court's requirement that he have an evaluation before release, but that was not at all related to negotiations. It was all about his continued detention.
Counsel, there's an email from the attorney to the prosecutor saying, we need the evaluation so we can negotiate. That's the attorney's statement to the prosecutor. It's in the record. There are two statements in the record from different hearings where the defense counsel says, we need this to negotiate.
I believe that that occurs after speedy trial has already run.
Well, at least one of them is June 27th. June 27th.
On June 27th, she again says that the therapist who was going to do this simple risk assessment that the court was requiring had decided she wouldn't do it. And she again asked the court to please consider release of GSS. She said that they had an offer, but it didn't consider his potential for rehabilitation, but she was advocating for release. She did not request a continuance of any trial because no trial was set. She wasn't asking to continue anything beyond speedy trial. In fact, as the court found, nobody was aware that this speedy trial provision even existed. They were all operating under the assumption that speedy trial would begin to run from the date of the not guilty plea, which was incorrect. The court was correct in recognizing its error, and the court in its ruling said nobody knew this statute existed. The court could have set the case for trial within speedy trial. The district attorney could have asked that it be set for trial within speedy trial, no matter what your attorney was requesting, because he was held without bond, and that's the key fact in this case, is the date of the no bond hold triggers the speedy trial deadline. It's not his plea anymore, it's the date of the no bond hold.
But how do we get from 19-2-509-4B to 18-1-405? Because neither statute cross-references the other. In fact, 19-2-108, or 2-108, I forget, it cross-references 18-1-405, but doesn't cross-reference 19-2-509. So we have to make some kind of a leap, it seems to me, to get even to 18-1-405.
You don't have to make a leap. You have to read the statutes together, as this court is required to do.
Well, why are we supposed to read statutes together that deal with different subjects and don't cross-reference each other?
They do cross-reference each other, and let me explain how.
Okay?
In 19-2-509, the court says the speedy trial deadline is 60 days from the no bond hold, or a not guilty plea, whichever is earlier. It doesn't say that having the no bond hold prevents the not guilty plea. You can have both, but it's whichever is earlier. Unless the juvenile requests a jury trial, then 19-2-1074 applies. That is the juvenile jury trial statute, which says that if a juvenile requests a jury trial, he waives the 60-day requirement, and instead 18-1-405 applies. And so in 509, you have a reference to other speedy trial provisions.
None of which apply here.
18, well then, and 18-1405 provides dismissal as a remedy. And in the juvenile speedy trial statute, it says the juvenile's right to speedy trial is governed by 18-1405.
That's right, but then it goes on to cross-reference a number of statutes, none of which is 19-2509. I mean, that's my problem. It seems, in other words, that 19-2108 is the speedy trial statute for juveniles. That's it. And it cross-references 18-1405. But we have a different kind of statute, a bail statute in 19-2509.
But it's completely different from the adult bail statute. And it does reference other speedy trial provisions.
Well, counsel, even if we get to 405, subsection 1 limits dismissal of the case to exactly one circumstance, where the trial does not occur within a certain number of days of an entry of a plea of not guilty by its express terms. One circumstance. In other words, if there's some other reason, there's some other circumstance, dismissal is not the remedy. And we don't have that circumstance.
I'm sorry, you need to tell me which statute
Yeah,
that we're.
18-1405-1.
Okay,
Okay. Dismissal is called for in one circumstance, and only one, that the trial doesn't occur within a certain number of days of an entry of plea of not guilty.
okay.
We don't have that.
Because the legislature has determined that because of the special considerations of juveniles in juvenile court, that speedy trial runs from the denial of pretrial release. And so it has this additional requirement in the juvenile code, which is very particular to juveniles, and considers all of the purpose behind the juvenile code. I would also like to say, before I forget, that this court has twice referred to 509 as a speedy trial statute. In both TA and GWR, divisions of this court referred to 509 as a speedy trial statute.
But neither of those cases involved dismissal of a case. Okay, neither one of them did. And it does appear that in both of them, you had pleas of not guilty, which we don't have, again.
Because in TA, the court released the no bond hold.
Yeah.
And this court found that 509 doesn't apply if the juvenile is released. That was the issue in that case, was whether 509 applied or 508 applied. And they found that 509 did not apply because the juvenile had been released from the no bond hold. And in GWR, this court specifically stated that the juvenile had waived the speedy trial protections of what was then 509 by accepting a date beyond speedy. And so both of those cases didn't result in dismissal because something had happened to extend the date or to make 509 inapplicable. But the issue was whether dismissal was appropriate. And here in this case, GSS was never released from the no bond hold. And that's the key fact in this case. The continued detention did not prevent a not guilty plea and did not prevent the court from setting trial. What should happen is, if the court determines at the initial detention hearing that the juvenile will be held without bond, he should set, or she should set, a 60-day speedy trial from that date. And if counsel wants to request a continuance to get an evaluation, then she can decide to waive the speedy trial date. That didn't happen here. No trial was set.
Ms. Hardiman, sorry,
Yes.
can I interrupt you here and
Of
just
course.
ask a question before we get too far away from Judge Jones' last question? Can you tell me how 19-2508-3A-4D impacts the discussion that we're having?
So 508, subsection 3, says that
and-
at the detention hearing,
Do you have that before you? I'm not trying to
I have a
test you to see if you can
summary
remember.
that
Okay,
I made in
all
my
right.
notes. Says that when there is no bail, they must be tried within the limits of 108, which is 60 days from a not guilty plea.
And 19-108 incorporates 18-1405, correct?
It does. And then 509 is more specific and says that actually if you are continued, a lot of times after a detention hearing, a plan will be made and a juvenile will eventually be released. But then 509 says when that does not occur and the juvenile is continued to be held, it's 60 days from the date of the no bond hold. The DA is asking for something that is not contemplated at all by the juvenile statutes. If the legislature wanted to include this same remedy from 16.4.101, if it had intended that remedy, it could have provided it, but it didn't. It provided no such.
But counsel, the exact same thing could be said about this situation. There's no statute that says you dismiss the case if there's a bond hold. There's no statute, not even 18.1405, that says that. So you have to read 18.1405 to say if the defendant pleads not guilty or if he's held without bond for more than 60 days. You have to add language to it.
You don't. You have to look at the juvenile code first and read them. They all overlap and cross-reference each other. You do have to read them together, which is how statutes are supposed to be interpreted.
But counsel, if we were dealing with an adult and the speedy trial deadline ran in a circumstance in which the adult had not pled not guilty, we wouldn't have to dismiss because the statute doesn't say you dismiss in those circumstances. I'm very confused about how we can take language that's very specific on its face in 18.405.1 and extend it to a situation that just isn't there.
It's because you start in 509, which then cross-references back through the juvenile statutes to 405.
Okay, it cross-reference, I don't agree with you, but even if it did, 405.1 is limited by its own terms to situations where somebody pleads not guilty.
No, because you start in 509, which says that the 60 days begins to run from the not guilty plea or the no bond hold order, whichever is earlier. And this is because the legislature has recognized that pretrial detention is so hard on juveniles. If you look at PV, it says that speedy is more important to juveniles than adults because of the psychological harm that it causes. And it recognizes that speedy delays undermine the purpose of the juvenile system. And the state's remedy doesn't account for the harm in delay, which is antithetical to the purpose of the Children's Code and the harm that was already done to GSS by the detention in this case.
Wait, can I just ask a quick clarifying question?
Of course.
Why doesn't it? Because I agree, there seems to be a very strong policy here that says do not lock children up for more than 60 days. But they say, great, he should just get let out then. Why doesn't that solve the problem?
Because here the court found that he was a danger to himself or the community and wouldn't consider release without the evaluation. It was the court and the prosecutor here who were requiring this evaluation. And I mean, releasing him, great, but I don't think that that also reflects the purposes of the code, which does allow the court to, in very narrow circumstances, continue to detain a child, but the child must be tried within 60 days because the continued detention is so harmful. Does that answer your question? I'm sorry.
I mean, I guess, but, so you're saying, well, what about the circumstances where that's not a good remedy because the kid is so dangerous? But if the kid is so dangerous, then he's gonna have to stay detained even after the adjudication. So,
But he is entitled to a determination on the adjudication. And here I'm not saying he is dangerous, but the court found that he was and wouldn't reconsider that without an evaluation. And the statutes do allow the court to continue to detain a child, but express a preference that if the child is continually detained, that he be tried quickly.
could I ask a technical-ish
Yes.
question? Okay. The AG says that the kid's lawyer asked for a continuance at those hearings where the kid's lawyer says, can you please release the kid? And I'm trying to figure out, is there something, I don't know. Was the lawyer supposed to say, Judge, let's just set it for a hearing, you're obviously not doing what we want, let's just set it for a hearing, we'll bring in the people who signed off on this release plan we have, and then you just have to make those findings and issue an order. Is that how it's supposed to work?
Defense counsel is never required to demand a trial. It's the court
No,
and
no,
prosecutors.
A detention hearing. They say she asked to continue the detention hearing.
So the first one is the initial detention hearing. And as long as a juvenile is detained, the juvenile can, at each hearing, readdress detention. And so that's why this court starts to call these dispositional hearings, because there really, in practice, isn't such a thing as repeated detention hearings. But that first one on May 2nd occurred 2 months before speedy trial ran. And there were two different defense counsels appearing, right? And so they kind of use different language. But even the defense counsel on May 2nd says assessment isn't necessary for release. He says, I want to make sure the evaluation is done correctly, but I want release as soon as possible. The prosecutor opposed release. On the next hearing, May 5th, he again said, charges are, the sooner the better on charges, and the prosecutor expressed ignorance on the timeline for filing charges. And then when the second defense counsel begins to appear, she clearly and repeatedly requests release without an evaluation. They had a detailed release plan. And on June 27th, she again requests that the juvenile be released without an evaluation. And it was the prosecutor in court who again said no release without this evaluation.
Counsel, I have a question about the record on that. It seemed to me there had been an initial evaluation, and then there was another evaluation going on, a second one. And at the hearing on August 1st, it said that the evaluation that we're talking about today had been requested by and paid by the defense.
Right, so there is discussion about two evaluations. The first one is what they call the simple risk assessment that the court wants done, that the court puts upon defense counsel to arrange, and the SB 94, the pretrial program. They're working together to try to arrange this. And because out in Durango, they don't have the services that we have here, for example, in Denver, they have trouble finding somebody to do it. And finally, on June 27th, defense counsel explains that the last therapist they had talked to got the instrument she was going to use and wouldn't do it. Defense, meanwhile, separately, had their own evaluation scheduled, and that's the one that eventually does happen.
And that's the evaluation that counsel says, I count at least 3 times, said she needed to negotiate a plea.
Those all occur after Speedy had passed.
June 27th was before.
She's,
And regardless, it shows her state of mind before. That's why she says on the record and says to the prosecutor in an email, that's why she wants the evaluation.
but that doesn't matter when what matters is the no bond, the date of the no bond hold. She can't waive a speedy trial date that has never been set, or a trial that has never been set, when all of the parties here are ignorant of what the statute, that the statute exists and what the speedy trial deadline is.
But
My time has way passed.
I
Is it okay if I
understand
keep
that.
talking to you?
Absolutely. So, but in Maines, okay, in that case, it was the same situation. There were plea discussions. Counsel says, I want more time for plea discussions. And that, the court said, is attributable to the defense. It's not a waiver of speedy trial, it's just an extension of it, okay? It's not a setting of beyond a trial date. I don't even know if a trial date had been set at that point. But the point is, the Supreme Court said that's attributable to the defense.
I disagree about Maines, and Maines is hard to read because there are so few facts in Maines. It appears that trial was set, to me, but it doesn't say exactly, but it says that defense requested continuances beyond the speedy trial deadline. And because trial happened, I assume it was set, but it's hard to, I don't think you can arrive at that conclusion from that reading of Maines because it's so unclear in its statement of facts.
But the point of Maines was, when trial counsel for the defendant requests extensions and continuances, to discuss the plea, those are attributable to the defense. Would you agree with that?
Had trial, I do disagree, had trial actually been set and had the trial court then requested a waiver of speedy trial, sure, but here they weren't operating under, they were operating under the assumption that because there was no guilty plea, or no plea at all, no not guilty plea, speedy trial wasn't running. Here she cannot waive, and the juvenile cannot waive speedy trial when nobody is aware that it's even running, which is different from Maine's.
I'm not going to give an additional 3 minutes, 36 seconds
Mike.
I'd
back
respectfully
to the
request this
appellant,
court affirm the court's order.
because I feel as though we may do this perpetually. So, thank you for
Thank
your
you.
arguments, and we will issue an opinion in due course. We will be in recess.
All rise.